The sitting is open.
L'audience
The
est
court
ouverte.
meets today to deliver in open court its decision on the request for indication of provisional measures submitted by South Africa in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. Judge Robinson, who duly participated in both the deliberation and the final vote, is, for reasons made known to me, unable to take his seat on the bench today. I would like to welcome the eminent representatives of the Republic of South Africa and the State of Israel who are in the Great Hall of Justice today. In particular, I recognize the presence of Her Excellency Ms. Naledi Pandor, Minister of International Relations and Cooperation of the Republic of South Africa. I recall that on 29 December 2023, South Africa filed in the Registry of the Court an application instituting proceedings against Israel concerning alleged violations in the Gaza Strip of obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, to which I shall refer as the Genocide Convention or the Convention. The application of South Africa contained a request for the indication of provisional measures submitted with reference to Article 41 of the statute and to Articles 73, 74, and 75 of the Rules of Court. In accordance with the usual practice, I shall not read the introductory paragraphs of the order which set out the procedural history of the case. I shall also omit or summarize some other paragraphs. I shall therefore begin the reading of the order at paragraph 13. In the order, the Court begins by recalling the immediate context in which the present case came before it. It observes that on 7 October 2023, Hamas and other armed groups present in the Gaza Strip carried out an attack in Israel, killing more than 1,200 persons, injuring thousands, and abducting some 240 people, many of whom continue to be held hostage. Following this attack, Israel launched a large-scale military operation in Gaza by land, air, and sea, which is causing massive civilian casualties, extensive destruction of civilian infrastructure, and the displacement of the overwhelming majority of the population of Gaza. The Court is acutely aware of the extent of the human tragedy that is unfolding in the region and is deeply concerned about the continuing loss of life and human suffering. The ongoing conflict in Gaza has been addressed in the framework of several organs and specialized agencies of the United Nations. In particular, reservations have been adopted by the General Assembly and the Security Council of the United Nations, referring to many aspects of the conflict. The scope of the present case submitted to the Court, however, is limited, as South Africa has instituted these proceedings under the Genocide Convention. The Court then turns to the conditions needed to be fulfilled in order for it to indicate provisional measures. With respect to the question of prima facie jurisdiction, the Court observes that it may indicate provisional measures only if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but it need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, South Africa seeks to found the jurisdiction of the Court on Article 36, Paragraph 1 of the Statute of the Court and on Article 9 of the Genocide Convention. The Court must therefore first determine whether those provisions prima facie confer upon it jurisdiction to rule on the merits of the case, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. Article 9 of the Genocide Convention provides, I quote, disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute. End of quote.
Fin de citation.
L'Afrique du Sud et Israël sont tous deux parties à la Convention sur le génocide. Aucun des deux États n'a formulé de réserve à l'article 9 ou à une quelconque autre disposition de la Convention. La Cour rappelle ensuite que l'article 9 de la Convention sur le génocide subordonne sa compétence à l'existence d'un différend relatif à l'interprétation, l'application ou l'exécution du dit instrument. Un différend est un désaccord sur un point de droit ou de fait, une contradiction, une opposition de thèse juridique ou d'intérêt entre parties. Pour qu'un différend existe, il doit être démontré que la réclamation de l'une des parties se heurte à l'opposition manifeste de l'autre. En outre, les points de vue des deux parties quant à l'exécution ou à la non-exécution de certaines obligations internationales doivent être nettement opposés. À l'effet d'établir si un différend existe dans la présente affaire, la Cour ne peut se borner à constater que l'une des parties soutient que la Convention s'applique alors que l'autre le nie. L'Afrique du Sud ayant invoqué comme base de compétence de la Cour la clause compromissoire de la Convention sur le génocide, la Cour doit également rechercher, au présent stade de la procédure, si les actes et les omissions dont la demanderesse tire grief semblent susceptibles d'entrer dans le champ d'application rationné matériel de cet instrument. La Cour rappelle que, pour déterminer s'il existait un différend entre les parties au moment du dépôt de la requête, elle tient compte notamment de toute déclaration ou de tout document échangé entre les parties, ainsi que de tout échange ayant eu lieu dans des enceintes multilatérales. Ce faisant, elle porte une attention particulière aux auteurs des déclarations ou qui en ont effectivement eu connaissance et à leur contenu. L'existence d'un différend doit être établie objectivement par la Cour. C'est une question de fond et non de forme ou de procédure. La Cour note que l'Afrique du Sud a fait dans différentes enceintes multilatérales et bilatérales des déclarations publiques dans lesquelles elle a dit estimer, au vu de la nature, de la portée et de l'ampleur des opérations militaires menées par Israël à Gaza, que les actions de celui-ci étaient constitutives de manquements à ses obligations au regard de la Convention sur le génocide. Ainsi, à la 10e session extraordinaire d'urgence de l'Assemblée générale des Nations unies, reprise le 12 décembre 2023, à laquelle Israël était représenté, la représentante permanente de l'Afrique du Sud a déclaré que, je cite, « Les événements des 6 semaines passées à Gaza montraient qu'Israël agissait au mépris des obligations lui incombant au titre de la Convention sur le génocide. » Fin de citation. L'Afrique du Sud a rappelé cette déclaration dans la note verbale datée du 21 décembre 2023 qu'elle a adressée à l'ambassade d'Israël à Pretoria. La Cour relève qu'Israël a écarté toute accusation de génocide dans le contexte du conflit à Gaza dans un document publié par son ministre des Affaires étrangères le 6 décembre 2023, puis mis à jour et reproduit le 15 décembre 2023 sur le site internet des forces israéliennes de défense sous le titre The War Against Hamas, Answering Your Most Pressing Questions. La guerre contre le Hamas répond à cette question les plus urgentes, affirmant que, je cite, l'accusation de génocide dont Israël faisait l'objet était non seulement dépourvue de tout fondement, en fait comme en droit, mais aussi moralement abjecte. Fin de citation. Israël déclare également que, je cite, l'accusation de génocide n'était pas seulement incohérente sur le plan juridique et sur le plan factuel, elle était aussi obscène et qu'il n'existait aucune base valable en fait ou en droit pour le chef infamant de génocide. Fin de citation. Compte tenu de ce qui précède, la Cour considère que les parties semblent avoir des points de vue nettement opposés quant à la question de savoir si certains actes ou omissions reprochés à Israël et à Gaza sont constitutifs de manquements par celui-ci aux obligations prévues par la Convention sur le génocide. Elle conclut que les éléments susmentionnés sont suffisants à ce stade pour établir prima facie l'existence d'un différend entre les parties relatif à l'interprétation, l'application ou l'exécution de la Convention sur le génocide. Pour ce qui est de savoir si les actes et omissions dont la demanderesse tire grief semblent susceptibles d'entrer dans les prévisions de la Convention sur le génocide, la Cour rappelle que l'Afrique du Sud considère que la responsabilité d'Israël est engagée au motif qu'il commet un génocide à Gaza et qu'il manque à l'obligation de prévenir et de punir des actes génocidaires. L'Afrique du Sud soutient qu'Israël a également manqué à d'autres obligations imposées par la Convention sur le génocide, notamment celles concernant l'entente en vue vue de commettre le génocide, l'incitation directe et publique à commettre le génocide, la tentative de génocide et la complicité dans le génocide. Au stade actuel de la procédure, la Cour n'est pas tenue de déterminer si Israël a, comme cela est allégué, manqué à l'une quelconque des obligations lui incombant au titre de la Convention sur le génocide. Une telle conclusion ne pourrait être formulée par la Cour qu'au stade de l'examen au fond de la présente affaire. Au stade d'une ordonnance sur une demande en indication de mesures conservatoires, la Cour doit établir si les actes et omissions dont le demandeur tire grief semblent susceptibles d'entrer dans les prévisions de la Convention sur le génocide. De l'avis de la Cour, au moins certains des actes et omissions que l'Afrique du Sud reproche à Israël à Gaza semblent susceptibles d'entrer dans les prévisions de la Convention. À la lumière de ce qui précède, la Cour conclut que, prima facie, elle a compétence en vertu de l'article 9 de la Convention sur le génocide pour connaître de l'affaire. Compte tenu de cette conclusion, la Cour considère qu'elle ne peut accéder à la demande d'Israël pendant ce qu'elle raye l'affaire de son rôle. La Cour en vient à la question de la qualité pour agir de l'Afrique du Sud. Elle note que, en affaire relative à l'application de la Convention pour la prévention et la répression du crime de génocide contre Myanmar, dans laquelle l'article 9 de la Convention sur le génocide était aussi invoqué, la Cour a fait observer que tous les États parties à la Convention sur le génocide ont, en souscrivant aux obligations contenues dans cet instrument, un intérêt commun à veiller à ce que le génocide soit prévenu, réprimé et puni. Un tel intérêt commun implique que les obligations en cause sont dues par tout État partie à la Convention à tous les autres États parties au traité en question. Ce sont donc des obligations erga omnes partes, en ce sens que, quelle que soit l'affaire, chaque État partie a un intérêt à ce qu'elle soit respectée. Il découle de l'intérêt commun à ce que soient respectées les obligations pertinentes énoncées dans la Convention sur le génocide, que tout État partie, sans distinction, est en droit d'invoquer la responsabilité d'un autre à raison d'une violation alléguée d'obligations erga omnes partes. En conséquence, la Cour a conclu que tout État partie à la Convention sur le génocide peut invoquer la responsabilité d'un autre État partie, notamment par l'introduction d'une instance devant la Cour, en vue de faire constater le manquement allégué de ce dernier à des obligations erga omnes partes lui incombant au titre de la Convention et d'y mettre fin. La Cour conclut prima facie que l'Afrique du Sud a qualité pour lui soumettre le différend qu'il oppose à Israël concernant des violations alléguées d'obligations prévues par la Convention sur le génocide. La Cour examine ensuite la question des droits dont la protection est recherchée et du lien entre ces droits et les mesures demandées. Elle rappelle que le pouvoir d'indiquer des mesures conservatoires qu'elle tient de l'article 41 de son statut a pour objet de sauvegarder, dans l'attente de ses décisions sur le fond de l'affaire, les droits revendiqués par chacune des parties. Il s'ensuit que la Cour doit se préoccuper de sauvegarder par de telles mesures les droits que la règle aura ultérieurement à rendre pourrait reconnaître à l'une ou à l'autre des parties. Aussi, ne peut-elle exercer ce pouvoir que si elle estime que les droits allégués par le demandeur sont au moins plausibles. À ce stade de la procédure, cependant, la Cour n'est pas appelée à se prononcer définitivement sur le point de savoir si les droits que l'Afrique du Sud souhaite voir protégés existent. Il lui faut seulement déterminer si les droits que l'Afrique du Sud revendique et dont elle sollicite la protection sont plausibles. En outre, il doit exister un lien entre les droits dont la protection est recherchée et les mesures conservatoires demandées. La Cour rappelle que, conformément à l'article 1er de la Convention, tous les États parties à cet instrument se sont engagés à prévenir et à punir le crime de génocide. L'article 2 dispose que, je cite, « Le génocide s'entend de l'un quelconque des actes ci-après, commis dans l'intention de détruire, en tout ou en partie, un groupe national, ethnique, racial ou religieux comme tel. A. Meurtre de membres du groupe. B. Atteinte grave à l'intégrité physique ou mentale de membres du groupe. C. Soumission intentionnelle du groupe à des conditions d'existence devant entraîner sa destruction physique totale ou partielle. D.
D. Mesures visant à entraver les naissances au sein du groupe.
E.
Transfert forcé
to another group. End of quote. Pursuant to Article 3 of the Genocide Convention, the following acts are also prohibited by the Convention: conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. The provisions of the Convention are intended to protect the members of a national, ethnical, racial, or religious group from acts of genocide or any other punishable acts enumerated in Article 3. The Court considers that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on state parties thereto, and the right of any state party to seek compliance therewith by another state party. As the Court has stated in other cases, in order for acts to fall within the scope of Article 2 of the Convention, the intent must be to destroy at least a substantial part of a particular group. This is demanded by the very nature of the crime of genocide, since the object and purpose of the Convention as a whole is to prevent the intentional destruction of groups. The part targeted must be significant enough to have an impact on the group as a whole. The Palestinians appear to constitute a distinct national, ethnical, racial, or religious group, and hence a protected group within the meaning of Article 2 of the Genocide Convention. The Court observes that, according to United Nations sources, the Palestinian population in the Gaza Strip comprises over 2 million people. Palestinians in the Gaza Strip form a substantial part of the protected group. The Court notes that the military operation being conducted by Israel following the attack of 7 October 2023 has resulted in a large number of deaths and injuries, as well as massive destruction of homes, the forcible displacement of the vast majority of the population, and extensive damage to civilian infrastructure. While figures relating to the Gaza Strip cannot be independently verified, recent information indicates that 25,700 Palestinians have been killed, over 63,000 injuries have been reported, over 360 housing units have been destroyed or partially damaged, and approximately 1.7 million persons have been internally displaced. The Court takes note in this regard of the statement by the United Nations Under-Secretary General for Humanitarian Affairs and Emergency Relief Coordinator, Mr. Martin Griffiths, on 5 January 2024. I quote, "Gaza has become a place of death and despair. Areas where civilians were told to relocate for their safety have come under bombardment. Medical facilities are under relentless attack. A public health disaster is unfolding. Gaza has simply become uninhabitable. Its people are witnessing daily threats to their very existence while the world watches on." End of quote. Following a mission to North Gaza, the World Health Organization reported that as of 21 December 2023, I quote, "an unprecedented 93% of the population of Gaza is facing crisis levels of hunger, with insufficient food and high levels of malnutrition." End of quote. The Court further notes the statement issued by the Commissioner General of the United Nations Relief and Works Agency for Palestine Refugees in the Near East, or UNRWA, Mr. Philippe Lazzarini, on 13 January 2024. I quote, "It's been 100 days since the devastating war started, killing and displacing people in Gaza following the horrific attacks that Hamas and other groups carried out against people in Israel. It's been 100 days of ordeal and anxiety for hostages and their families. In the past 100 days, sustained bombardment across the Gaza Strip caused the massive displacement of a population that is in a state of flux, constantly uprooted and forced to leave overnight, only to move to places which are just as unsafe. This war affected more than 2 million people, the entire population of Gaza. Many will carry lifelong scars, both physical and psychological. The vast majority, including children, are deeply traumatized." Overcrowded and unsanitary UNRWA shelters have become home to more than 1.4 million people. They lack everything, from food to hygiene to privacy. People live in inhumane conditions where diseases are spreading, including among children. They live through the unlivable with the clock ticking fast towards famine. The plight of children in Gaza is especially heartbreaking. An entire generation of children is traumatized and will take years to heal. Thousands have been killed, maimed, and orphaned. Hundreds of thousands are deprived of education. Their future is in jeopardy with far-reaching and long-lasting consequences. The UNRWA Commissioner General also stated that the crisis in Gaza is, I quote, compounded by dehumanizing language, end of quote. In this regard, the court has taken note of a number of statements made by senior Israeli officials. It calls attention in particular to the following examples. On 9 October 2023, Mr. Yoav Gallant, Defense Minister of Israel, announced that he had ordered a complete siege of Gaza City, and then that there would be no electricity, no food, no fuel, and that everything was closed. On the following day, Minister Gallant stated, speaking to Israeli troops on the Gaza border, I quote, "I have released all restraints. You saw what we are fighting against. We are fighting human animals. This is the ISIS of Gaza. This is what we are fighting against. Gaza won't return to what it was before. There will be no Hamas. We will eliminate everything. If it doesn't take one day, it will take a week. It will take weeks or even months. We will reach all places." End of quote. On 12 October 2023, Mr. Isaac Herzog, President of Israel, stated, referring to Gaza, I quote, "We are working, operating militarily according to rules of international law, unequivocally. It is an entire nation out there that is responsible. It is not true, this rhetoric about civilians not aware, not involved. It is absolutely not true. They could have risen up. They could have fought against that evil regime which took over Gaza in a coup d'etat. But we are at war. We are at war. We are at war. We are defending our homes. We are protecting our homes. That's the truth. And when a nation protects its home, it fights. And we will fight until we break their backbone." End of quote. On 13 October 2023, Mr. Israel Katz, then Minister of Energy and Infrastructure of Israel, stated on X, formerly Twitter, I quote, "We will fight the terrorist organization Hamas and destroy it. All the civilian population in Gaza is ordered to leave immediately. We will win. They will not receive a drop of water or a single battery until they leave the world." End of quote. The court also takes note of a press release of 16 November 2023, issued by 37 special rapporteurs, independent experts, and members of working groups part of the special procedures of the United Nations Human Rights Council, in which they voiced alarm over, I quote, "discernibly genocidal and dehumanizing rhetoric coming from senior Israeli government officials." End of quote. In addition, on 27 October 2023, the United Nations Committee on the Elimination of Racial Discrimination observed that it was highly concerned about the sharp increase in racist hate speech and dehumanization directed at Palestinians since 7 October. In the court's view, the aforementioned facts and circumstances are sufficient to conclude that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. This is the case with respect to the right of Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. The court then turns to the condition of the link between the plausible rights claimed by South Africa and the provisional measures requested. It considers that by their very nature, at least some of the provisional measures sought by South Africa are aimed at preserving the plausible rights it asserts on the basis of the Genocide Convention in the present case, namely, the right of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts mentioned in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. Therefore, a link exists between the rights claimed by South Africa that the Court has found to be plausible and at least some of the provisional measures requested. The Court turns next to the question of risk of irreparable prejudice and urgency. It notes that, pursuant to Article 41 of its statute, it has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are the subject of judicial proceedings, or when the alleged disregard of such rights might entail irreparable consequences. However, the power of the Court to indicate provisional measures will only be exercised if there is urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the Court gives its final decisions. The condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment, before the Court makes the final decision in the case. The Court must therefore consider whether such a risk exists at this stage of the proceedings. The Court is not called upon for purposes of its decision on the request for the indication of provisional measures to establish the existence of breaches of obligations under the Genocide Convention, but to determine whether the circumstances require the indication of provisional measures for the protection of rights under that instrument. As already noted, the Court cannot at this stage make definitive findings of fact described in point 1 above. In favor, President Donoghue, Vice President Gevorgyan, Judges Tomka, Abraham, Benuna, Youssef, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sabatinde, Judge Ad hoc Barak. By 16 votes to 1, the State of Israel shall take all measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to members of the Palestinian group in the Gaza Strip. In favor, President Donoghue, Vice President Gevorgyan, Judges Tomka, Abraham, Benuna, Youssef, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judges Ad hoc Barak, Moseneke. Against, Judge Sabatinde. By 16 votes to 1, the State of Israel shall take immediate and effective measures to ensure the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. In favor, President Donoghue, Vice President Gevorgyan, Judges Tomka, Abraham, Benuna, Youssef, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judges Ad hoc Barak, Moseneke. Against, Judge Sabatinde. By 15 votes to 2, the State of Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Convention on the Prevention and Punishment of the Crime of Genocide against members of the Palestinian group in the Gaza Strip. In favor, President Donoghue, Vice President Gevorgyan, Judges Tomka, Abraham, Benuna, Youssef, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sabatinde, Judge Ad hoc Barak. By 15 votes to 2, the State of Israel shall submit a report to the Court on all measures taken to give effect to this order within 1 month as from the date of the order. In favor, President Donoghue, Vice President Gevorgyan, Judges Tomka, Abraham, Benuna, Youssef, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sabatinde, Judge Ad hoc Barak. I shall now call upon the registrar to read the operative part of the order in French.